The Senate ultimately rejected the court packing plan. Meanwhile, the Supreme Court had shifted direction, perhaps in response to the proposed court packing plan, and began to uphold elements of FDR's New Deal legislation. The 1937 case of NLRB v. Jones and Laughlin Steel concerned the National Labor Relations Act, a New Deal statute that regulated labor practices through the National Labor Relations Board, the NLRB. Jones and Laughlin was the kind of enterprise populist reformers loved to hate, an integrated enterprise with mines, ore steamships, railroads, and warehouses around the country. Notice J&L's argument that the statute has the fundamental object of placing under the compulsory supervision of the federal government all industrial labor relations within the nation. We see the same kinds of arguments about the regulatory state today. This time, however, a 5-4 majority upheld the regulation. Justice Hughes's reasoning resonates with one of the key themes of Gibbons v. Ogden, the extension of interstate commerce into the interior of a state, but perhaps goes further than Gibbons. Hughes said that even activities that are interstate in character when separately considered may affect interstate commerce if they have such a close and substantial relation to interstate commerce that their control is essential or appropriate to protect that commerce from burdens and obstructions. Hughes's opinion drew a dissent written by Justice McReynolds and joined by Justices Van Devanter, Sutherland, and Butler, a group that came to be known as the Four Horsemen for their dissents as the majority of the court shifted toward approval of New Deal legislation. Notice their rhetoric about what the federal government could regulate under the majority's reasoning. Almost anything, they argued, marriage, birth, death, may in some fashion affect commerce. United States v. Darby Lumber, decided in 1941, shows how far the court had shifted from the pre-New Deal era. This case involved a provision of the Fair Labor Standards Act that prohibited the shipment in interstate commerce of lumber manufactured by employees whose wages or hours fell outside the Act's requirements. This should remind you of Hammer v. Dagenhart, the child labor case, which was expressly overruled by the majority opinion in Darby. Notice how broadly Justice Stone conceived of federal power in relation to the traditional state police powers. He said, Congress is free to exclude from the commerce articles whose use in the states for which they are destined it may conceive to be injurious to the public health, morals, or welfare, even though the state has not sought to regulate their use. Moreover, Justice Stone held, Congress may choose any means reasonably adapted to the attainment of the permitted end, even though they involve control over interstate activities. For many conservatives, both at that time and today, the 1942 case of Wickard v. Filburn represents the nadir of Commerce Clause jurisprudence. The Agricultural Adjustment Act of 1938, the statute at issue in Wickard, was the successor to the Agricultural Adjustment Act of 1933. The 1933 statute was a response to the dramatic effects of the Great Depression on the agricultural sector, and in particular on the tenant farming and sharecropping systems that predominated in the post-Civil War South. In a tenant farming system, a landlord owns the land and contributes financial capital while tenant farmers contribute labor. In a sharecropping system, the tenant farmer pays the landowner with a share of the crops produced. You may notice that these systems have historical roots in feudalism. American farms were producing more wheat, cotton, corn, tobacco, and other commodities than the market could absorb, causing prices to fall. This, of course, is the basic law of supply and demand. If supply exceeds demand, price will fall. All other things being equal from a free market perspective, the best response to overproduction is to let the market correct itself. Some suppliers will exit the market and put their capital to other productive uses. Supply of the original commodity will reach equilibrium with demand, and overall social welfare will expand because excess capital will be directed to other productive uses. This is a feature, not a bug, of a market economy. There are at least 3 potential problems, however, with market self-correction for agricultural production, particularly if market corrections are relatively sudden and steep. First, the national food supply, like basic health care, involves significant externalities, because if people are not well nourished, they become ill and unproductive. This also, of course, presents a moral imperative concerning society's collective responsibility to ensure that people have enough to eat. Second, a significant portion of agricultural workers are unskilled laborers who cannot easily find alternative work. A dramatic market correction in the agricultural sector can leave these workers without employment or opportunities for retraining, amplifying the negative externalities and moral issues of possible food shortages. Third, if a landowner exits agricultural markets and puts her land to other uses, say for industrial production, that land may become permanently unavailable for agriculture. As a nation's stock of arable land diminishes, the population potentially becomes more vulnerable to risks of local drought, blight, weather, or other negative events, and more reliant on imported food supply, all of which can affect public health, economic productivity, and national security. As with healthcare, then, there are both economic and moral reasons for government intervention in agricultural markets. The Agricultural Adjustment Act of 1933 sought to incentivize farmers to reduce production of key commodities through contracts with the U.S. Secretary of Agriculture, which would provide benefit payments to the farmers for the reductions. Money for these benefit payments was obtained through a tax paid by the processors of these commodities. For example, by a mill that processed wheat into flour. This scheme was held unconstitutional in the 1936 case of U.S. v. Butler, which we'll come back to in Unit 5 when we discuss the taxing and spending powers. After the 1933 statute was held unconstitutional, the Roosevelt administration and Congress came up with a new scheme in the Agricultural Adjustment Act of 1938. Under the 1938 statute, the Secretary of Agriculture was authorized to impose market quotas on commodities such as wheat and corn, with price supports provided by the federal government out of general revenue and penalties imposed on producers who exceeded their quotas. Elements of this kind of price control system remain part of American agricultural policy today. Filburn was a dairy farmer who was fined by the Department of Agriculture for exceeding his quota of wheat by 239 bushels. Filburn planned to sell some of the excess, but also to use it for seed, feed for his livestock, and home flour production. Critics of Wickard v. Filburn seize on this home use element of the case, as though the federal government was penalizing Filburn for growing a backyard garden. But a bushel of wheat is actually 60 pounds of wheat, which can yield about 42 pounds of white flour, enough to bake about 200 loaves of bread. So Filburn's 239 bushels could have produced about 47,800 loaves of bread. On the other hand, although wheat is a poor feed for cattle, a cow can be fed about 5 pounds of wheat a day. Filburn in fact used his excess wheat to feed his dairy cows and his chickens. Even then, if Filburn and farmers like him were free to grow their own feed, this could also undermine the broader price controls for feedstock commodities. In any event, Justice Jackson wrote for a unanimous court and expressed an expansive, seemingly nearly unlimited view of the federal commerce power. According to Justice Jackson, effective restraints on the exercise of the commerce power must proceed from political rather than from judicial processes. In other words, the scope of economic regulation was a matter of political deliberation, and the court would not get involved, at least not under the Commerce Clause. Further, Justice Jackson said, mechanical legal formulas are no longer feasible, and even if appellee's activity be local, and though it may not be regarded as commerce, it may still, whatever its nature, be reached by Congress if it exerts a substantial economic effect on interstate commerce. And this, irrespective of whether such effect is what might at some earlier time have been defined as direct or indirect. Incidentally, the former location of Filburn's farm outside Dayton, Ohio, is now occupied by a Home Depot. There's an interesting lesson or observation here about the demise of the small American farmstead, the rise of megacorporations, and the homogenization of American culture, but I'm not really sure what it is. As one of the notes in our casebook after Wickard mentions, the court's composition changed dramatically between Jones and Laughlin and Wickard. By the time Darby and Wickard were decided, none of the four horsemen remained on the court. This is a clear demonstration of how changing historical circumstances and a different composition of justices can affect constitutional doctrine.